conduct a session with Mr. Vaibhav Srivastava. He is an advocate in Allahabad High Court, and we are going to know about the topic about how we are going to get in-depth insights on from investigation to trial. Over to you, sir.
Thank you, Sanskriti. Hello, everyone. So, I will be dealing today uh, with the journey from investigation to trial. That is, from when the first information has been received and till the trial. So, I will be sharing my screen. It's visible to everyone.
Yes, sir.
Yeah, thank you. So, chapter 12 of CRPC, that is Code of Criminal Procedure, deals with the information to the police and their power to investigate. So, there are total 26 sections, that is from section 154 to 176. So, it is very basic to know that the offense are of two type, that is cognizable offense as well as non-cognizable offense. So, how one can know what offenses are cognizable offense and what offenses are non-cognizable offense? So, for that, the CRPC provides first schedule. So when you look at the criminal manual or when you look at the back of the CRPC, you will find the offenses which are cognizable in nature, which are non-cognizable, which are bailable, non-bailable, as well as compoundable and non-compoundable. Along with that, there are state amendments. Like not every offense can be compoundable in one state which is non-compoundable in other, right? So the first instance, the first information which is received, it is known as first information report, right? And that complaint, if if the offenses, if the contents of the first information report uh, says the nature of the offense is of cognizable type, that is no warrant is required, then it's a serious offense. And when the information is of a cognizable offense, then it is dealt with section 154 of the CRPC. Okay, so if you look at the proviso of 154, section 154 of the CRPC, we find that if the information is given by the woman, so if the information is given by the woman against the offenses related to the woman, then it must be registered by a woman police officer only, right? Further, if we look forward to the other proviso, we find that if someone is temporarily or permanently mentally or physically disabled due to the offense caused to her or him, then in such information shall be recorded by the police officer at the residence of the person, at the residence of the person and at the convenient place of such person's choice, right? In the presence of interpreter or special educator. So if an information is received at a police station, or if a police receives an information, so police, if finds it to be a the facts of the cases or the contents of the FIR, when it's seen by the police and when the police find it to be a cognizable offense, then police will register an FIR under 154, right? And that FIR's free copy is given to the informant. If a person X is the informant and he is giving lodging an FIR to the police station, then a free of cost copy should be given to him or her. Now, if the information if the information is not being registered by the police officer, or there is some kind of refusal on the part of the officer in charge of the police station, like we see in many movie series uh, or serials or dramas on OTTs, like police refuses to register an FIR, then in such cases, by writing in a post to the superintendent of the police concerned, an FIR may be lodged, right? So moving on to next, there is section 155. This talks about non-cognizable offense. So non-cognizable goes with non-serious matter. If the matter is of non-serious, then it is termed as a non-cognizable offense. And in this case, there is a provision of NCR. We have understood what is FIR. It has not been defined anywhere in CRPC, but same NCR has also been not been defined, and it is known as non-cognizable report. So non-cognizable report is a report where the offense is of non-cognizable in nature, that is non-serious in nature. Okay, so when we go move forward, we find that section 155 of subsection 2 of 155, that police without the magistrate permission will not investigate in the non-cognizable matter. This is important section. Why police without magistrate's permission will not investigate? This is because this is so because non-cognizable offense are categorized as a non-serious in nature, and the police can investigate into a serious matter, that is cognizable offense, without the warrant, without the permission. That's why in non-cognizable offense we withdraw the power of magistrate to give permission to the police to investigate if we find so that an investigation is required in a non-cognizable offense, right? There too, when we read subsection 3, use the same method of investigation as the cognizable offense except the power to arrest without a warrant. So basically, I will not be going into to dive into the sections. These are just a crux and the points I have made for a better understanding. So yeah. So uh, let's consider for an instance, there an offense of 302 IPC, like if murder is committed. So FIR is the basic document, and it has FIR will be lodged because 302 falls under the cognizable offense. And then there too, if we go into the basic methodology, then we find the police will decide to register an FIR on the fact that it disclosed the cognizable offense, right? And then under section 155 subclause 2, magistrate gives the permission if required for an investigation. For an instance, if a offense of non-cognizable in nature, if a non-cognizable offense has been committed and police without the permission of magistrate performs the investigation, then it is illegal, arbitrary, and injustice to law. So for that, one can approach High Court in writ as well as 482 jurisdiction, which is the inherent power of High Court. Okay. So for the basic foundation, when an offense is created, it can be of two types: cognizable offense, non-cognizable offense. Cognizable offense given under section 154, non-cognizable offense given under section 155. Police will find the contents, find the fact. If it's matched with the cognizable offense, then it will lodge FIR under section 154. Otherwise, it is a non-cognizable offense and it will be go under section 155. So basically, FIR is the first document and the basic document. After that, police will, just giving you all the outline, the police will go under 161. That is the statements of the witness as well as informant. If a offense of 302, that is murder, has been committed, then there must be some eyewitness, the statement of eyewitness. There must be some informant who has informed that the murder has been committed, and there is another witnesses who are secondary and tertiary in nature, their statement, which gives the whole, which connects the whole ingredient of 302 to give mens rea, the intention behind it, to give the motive behind the murder. And then when it's clubbed together, the police records the statement of these witnesses as well as the informant under section 161 of CRPC. Second to that, under section 164 of the CRPC, under section 164 of the CRPC, you will find that a statement of the witnesses as well as the informant is recorded in front of the magistrate. So when you compare section 161 and 164, there are plethoras of judgment of Supreme Court where you can find that 164 will prevail when it's come to the statements of witnesses as well as the informant, because 161 statements are considered to be recorded under undue influence by the police, some kind of external pressure, and miscellaneous other threats which you can find under section 24 of Indian Evidence Act. When you see section 24 of Indian Evidence Act that deals with the threat and inducement. So moving forward, FIR has been registered, 161 has been recorded, 164 has been recorded. Clubbing with that, collecting the external documentary evidence like forensic, like medical, any kinds of blood stain at the spot, inquest report, panchnama, which we call it, post-mortem report. These all three, four things are clubbed together and police prepared a report known as charge sheet. So when you see section 173 of the CRPC, you will find that it's a report of police officer on a completion of an investigation. This charge sheet is also termed as challan. It can also be termed as final report. All are same in nature. Like it can be completion report, it can be final report, it can be challan or charge sheet. There are four names to this, right? So FIR register 161 has recorded, 164 has been recorded, clubbing with the collecting all the documents, forensic, medical, and external things. Police prepare a charge sheet, and that charge sheet is submitted, contains all the document, and it has been seen under section 173 of the CRPC. So after charge sheet is submitted to the concerned magistrate, there are two things. One, to summon the accused to proceed with the trial, to summon the accused and proceed with the trial. And second, there is no material are forthcoming against the accused and the case should be closed. Charge sheet is basically the whole report and the document or the evidence enclosed, encapsulated, clubbed together to find out, to show, to suggest that how many accused are there, how many witnesses are there, how the offense is being made, and how the ingredients of that particular offenses falls out. So it's basically a whole gist of that offense related to that accused. And when it's submitted to the concerned magistrate, the magistrate has two things to do, two points. First, to summon that accused if he finds there is an ample amount of evidence, there is a proper way to proceed to the trial. Second, there is no material forthcoming and there is no evidence or the any kind of document supporting the accused, and to close the case, right? Okay, so moving ahead, when we talk about closing the case, first we talk about the summoning of the accused if the sufficient evidence is made out. So the trial will run. But in the other case, when we talk about closing the case, there's been report known as closure report. So closure report is being submitted. And for instance, uh, the charge sheet is prepared by the police officer. Okay, the police officer concerned prepares the charge sheet, but the final view and the opinion always lies to the IO. So IO will be the investigating officer, and that will be the rank of sub inspector, right? So the final forwarding of the charge sheet is done by the IO to the magistrate concerned, as well as the IO will find out if there is an addition to the charges. I must tell you all, if an FIR is registered under 302, that is not sufficient only that that section will remain. When the charge sheet is being submitted, the section may be increased. Maybe it's a offense of theft with murder, or dacoity with murder, or there are more than one people having the common intention to 302 read with 34. There must be writing and then murdering. Then the section will be increased 302 read with 147, 148, unlawful assembly 149. So it all depends on the opinion of the IO whether the crime is being committed by XYZ is made out. And you will find in many of the cases that FIR has been registered on ABC person and the charge sheet has been submitted only on A. To the other cases, you will also find that in theft cases, mostly the FIR is being registered as an unknown person. But after investigation, after enclosing CCTV footages, after having the statements of the witnesses and other uh, related people, the charge sheet gives a name of the accused, and then the charge sheet is filed uh, on that basis. So charge sheet is a very important document which also leads to the addition of charges as well as addition of accused. So the closure report is filed. We have reached till that the closure report is filed to the magistrate concerned that the case is not made out. So the magistrate has three things to do. The magistrate can do three things. First, to accept the report, the magistrate can accept the report, or secondly, acceptance means that the magistrate is satisfied enough with the closure report filed by the investigating officer and closes the case. Second, if magistrate feels while seeing the other documents attached to the closure report that there is still a clues available, there is some kind of uh, part lacking on the investigating agencies, so magistrate may order for the further investigation. Magistrate is not satisfied with this investigation, the investigation which has been done by the police for the first time and for first instance, and police is submitting the closure report to the magistrate concerned, but the magistrate is not satisfied with the investigating agency or uh, authorities or investigating agencies investigation report. So he or she may ask for the further investigation. And for the third thing he can do is to summon the accused. To summon the accused if he finds the element in that closure report is enough to call upon the accused to record his statement and to proceed with the trial. So, offense has been committed, FIR has been lodged, 161 recorded, 164 recorded, all the documentary evidence, forensic, medical, has been recorded, clubbing together, charge sheet has been formed. Two things: the accused may be summoned and directly proceed with the trial. Second, no material found, closure report has been submitted. The closure report submitted to the concerned magistrate. The magistrate had three things to do: to accept the report, to go for the further, three things to do: to accept the report and to go for the further investigation. And third, to summon the accused. If he finds that this closure report has the enough of material to incriminate the accused. So everyone has heard of Arushi Talwar case, right? Am I audible to everyone? Hello.
No, sir, I haven't
Yes,
heard
yes,
about
yes.
that case.
You are audible, and we have all heard about this case.
Okay. So there's a movie on that also, Talwar. Uh, it's a famous murder case where there is a lacuna of CBI. So CBI, first thing first, CBI is just a police wing, but with the different powers. So comes under the central act of administration and all. So in Arushi Talwar's case, there has been a closure report submitted to the concerned magistrate, and the accused was summoned only on the basis of that the magistrate finds the elements are enough in the closure report to summon the accused. However, investigating agency has submitted the closure report, but the closure report that's is submitted by CBI, they asked for closure, but uh, in their arguments in front of the magistrate, they disowned their own closure report and asked for summoning of accused, while the Dr. Rajesh Talwar, who was the first informant and the father of the victim of the case, asked for the further investigation. So when you, I am forgetting the name of the movie. When you go and watch the movie related to this Talwar, I think movie name is Talwar only. So there is a whole lot of drama that CBI has not performed their duties properly, and that too the closure report has been submitted by the CBI, but in their arguments in front of the magistrate, they disowned their own closure report and they asked for summoning of accused. At one parameter, they are submitting closure report, and the other parameter, when they are doing argument in advance, they are asking for the summoning of accused. While the informant of the case, that is Dr. Rajesh Talwar, asked for the further investigation. The court denied the closure. The court denied the plea for further investigation as prayed by Dr. Rajesh Talwar. But the court agreed on to summoning of the accused. That is the third option. The magistrate availed the third option which he had. He finds the enough elements, enough ground of that murder case in that closure report and summoned the accused. So in this case, Talwar case, a closure report was filed by the CBI saying that there was a gap in investigation which could not justify them. Therefore, they asked the court to close the case only on that sole reason that there was a gap in investigation. So, in this case, in the Arushi Talwar case, when you will see the movie or when you will read the case in a crux or on a summary basis, you will find out that the blood stains which has been on the terrace of the house of the victim has been washed in the rain because of the gap in the investigation, because of the delay in the investigation. There has been 2 3 investigating agencies involved. First failed, second failed, third failed. So the point I'm making here is a lot of things depends on how investigating agencies do their task. On the daily basis, they maintain a diary known as case diary. When you look into, I will be sharing the screen. Wait for a while. Is it visible? Yeah. So when you see section 172 of the CRPC, it clearly says police to prepare a case diary. Day by day investigation and the proceedings of that investigation. This case diary is also known as special diary, police diary, and a station house diary. Earlier, 5 years before the lane, I'm telling this thing in the state of Uttar Pradesh, there has to be a handwritten case diary. But nowadays, there has been printed pro forma full of diary, uh, which is more gimmick than earlier is It used to be, because it's just a cut copy paste business which is being doing and done by the investigating agencies nowadays. One statement given by eyewitness number 1 is being copied as same as it is eyewitness number 2, same as it is at witness number 3, without doing any hustle. So going back to the case, there was one case of Supreme Court, this Balwant Singh versus Commissioner of Police. There is a procedure when a closure report is submitted to the magistrate, a notice has to be issued to the informant. You will not found this in any statute, because this is not laid down in any statute. It's in the practice from the judgment of Balwant Singh versus Commissioner of Police. So it is very thoughtful and in a common prudent to think that if there is an informant who has filed a case, he is not knowing that a closure report to his information has been filed. Therefore, there has been the provision of giving notice to the informant. That's why Dr. Rajesh Talwar was also there when the closure report had been submitted, because he was the first informant of the case and he pleaded for the further investigation. Right? So, closure report has been submitted. There are three options to the magistrate. First, to accept that report and close the case. Second, to go for the further investigation. And third, to summon the accused. Now, there's an important section of section 204. 204 of CRPC. 204 of CRPC. Wait a minute. Okay, yeah. So 204 of the CRPC, under section 204 of CRPC, magistrate exercise its power to summon the accused. The closure reports had been filed and the magistrate is satisfied enough with the element of the closure report to summon the accused. Magistrate will summon the accused under section 204 of the CRPC. Right? So, after the charge sheet has been filed, the first important judicial function the court exercise is to take the cognizance. Everyone has heard about the term cognizance, right? So, cognizance means, in Hindi, it means संज्ञान लेना, or to in a layman terms, you can say cognizance is basically the application of the mind of the magistrate to find out or to look into whether an offense is committed or not. So when you read out section 190 from the CRPC, you will find out that applying his or her mind to the facts of the cases and coming to the conclusion that there is the sufficient ground to proceed, the magistrate take the cognizance. This cognizance is taken before the summoning of accused. An offense has been committed, FIR has been registered, all the documents have been clubbed together, a charge sheet has been filed, right? After that charge sheet has been forwarded by IO, investigating officer, to the concerned magistrate, if the magistrate finds the enough ground, sufficient ground to proceed, he may take cognizance. So when you go to section 190 of CRPC, I must assuming everyone is having a Bear Act with them. If not, so you may open it in the mobile or a device which you are on. When you look at section 190 of the CRPC, you will find that there are three things a magistrate can do after taking cognizance. Or, in other words, a magistrate can take cognizance on three things. First, on a private complaint. Second, on a police report. Third, on an information he may receive from any public, any media, or anywhere other than these two. So, in general, when a police files its report, that is, police report is filed under section 173 of the CRPC, then magistrate take cognizance under section 190 subclause 1b, that is second point. When you look at it, upon a police report, and the first one talks about the receiving complaint, and the third one talk about any information from any person other than police officer or upon his own knowledge. In general, we look at the justices of high courts and all took suo motu cognizance, or Supreme Court suo motu cognizance. So they talk about by their own knowledge. Upon his own knowledge means that only. So moving forward, this is the basic procedure of a state case. An information is registered to the police station. Police lodged the FIR. The FIR, along with 161 statement in front of the police, 164 statement in front of the magistrate, clubbing with the other important documents together, filing of a charge sheet under 173, and then whether the case is made out or a case is not made out, the magistrate will take cognizance, applying his or her mind on a police report, that is section 191 or subclause B. On a police report, a magistrate will take cognizance, and under section 204 CRPC, magistrate will issue summon. Right? Hello. Am I audible? Yeah. Any questions so far? Anyone? Or we can keep the questions at last. Okay. So moving ahead, When we talk about complaint case, so complaint case suggests there has been a complaint filed and not an FIR. So not everybody go to police, or maybe he or she has gone to the police, but the police has failed to register the FIR. These are the common uh, things in day to day life. If you have watched the series name Ashram, or if you have uh, looked behind the case of Ashram Bapu and these type of gurus and all, first instance the police always, because of their influence, the power, the police always fail to register the FIR. So one can file complaint. The complaint is defined under section 2 of the CRPC. But when you see section 191A, you will find out the magistrate will take cognizance under this section and not under 191B, because it's not a police report, it's a private complaint registered by a person whose complaint has been failed to be registered by the concerned police officer. And again, when the cognizance has been taken by the magistrate, it will proceed with section 200 of CRPC. At one instance, we saw there is section 161 of the CRPC, that is the statement in front of police officer in case of FIR when registered. But on the other hand, when FIR has not been registered and there is a complaint, then we will see section 200 of the 200 of the CRPC, where it provides for the examination of the complainant and registration of the statement of the witnesses. When we look further, section 203 of the CRPC talks about dismissal of the complaint when there is no sufficient ground on examining the statement which has already been recorded under section 200 of the CRPC. The magistrate may dismiss the same complaint, but if there is a sufficient ground, then magistrate may issue off process under section 204 of the CRPC. So if we look behind from what we have learned till now, we find out that the summoning is common in both the cases. In state cases as well as in complaint cases, the summoning is performed under section 204 of the CRPC. However, in a complaint case, procedure is slightly less in terms of investigating. If a private person lodge or registered a complaint, then only solely and on only that basis the magistrate will summon the accused. But in a state case, there is a whole process of conducting investigation by the investigating agencies as well as authorities, clubbing all the documents, filing the charge sheet. So When the complaint case has the high profile involvement, or the gravity is high, or there is some high influential people involved, then police under section 156 subclause 3, 156 subclause 3 is empowered to order investigation. So we can see that the sections are given in a sequential way, but if you go and read and connect it as a story, that's what happening behind the door of that investigation, you will find out that the sections are eventually connected with each other, but not in a straight very method. So the last point we have learned is that the complaint case procedure, if having a high gravity, and if there is a high gravity involved in that offense, or the offense is of that nature that requires an investigating agency such as police, such as CBI, such as SIT, then a magistrate under section 156 subclause 3, there is an application in the lower court of this nature filed before the magistrate, and if the magistrate deems fit the grounds and the facts, he may order for the investigation. So earlier in the state case, if you can recall, we have read that there is a cognizance by the magistrate and then summoning of the accused. But when I ask you all that this investigation under section 156 subclause 3, it's a pre-cognizance stage or a post-cognizance stage? Anyone would like to answer that? Am I audible to everyone?
Yes, sir, you're audible.
Anyone would like to answer? That section 156 subclause 3 is a pre-cognizance or a post-cognizance stage? Okay, so silence indicates two things. One, you all know more than that what I'm here to say, or you know nothing. Okay, so moving forward, this police investigation under section 156 subclause 3 is a pre-cognizance stage, and after this 156 subclause 3, there will be entire state case procedure is followed, because now the complaint has been converted into a state case by the magistrate when he orders the investigating authority to investigate into the case. So in a basic layman language, a complaint case is the case which is being dealt only by magistrate, but a state case is a case which is being dealt by investigating authorities and agencies, and the last choice of action is with magistrate, right? So uh, have you heard of the term protest petition? Anyone anyone have you heard of the term protest petition? You can write in chat also. It's not necessary to speak if you're not. No. Okay. So, as the name suggests, protest petition. There is no such concept of protest petition given in CRPC. And when the closure report is filed, you all people are familiar with closure report, as we have talked 15-20 minutes before about the closure report. When the closure report is filed, the first informant, let's go to that example only, Talwar case. The first informant, that is the father of the victim, Dr. Rajesh Talwar, has the right, has the opportunity to resist the closure report. If I am the informant in a case and I don't want the case to be closed, I am objecting that closure report, then I am having the opportunity, I am having the right to file a petition known as protest petition. Nowhere defined in CRPC, protest means protesting against closure report. That's it. The name speaks it all. Protest means you are protesting the report, and that report is closure report. So even if closure report is accepted by the magistrate, and the magistrate may take cognizance under section 191A, protest petition can be filed by the first informant. And now you will connect that Balwant Singh case is so important that if an informant doesn't knows about the filing of closure report, how can he protest it? How can he resist it? So the protest petition means you as a informant of the case having some incriminating evidences, some kind of documents, some things which are hidden from the police, which are not included in the closure report. Then you are converting this protest petition into complaint, because we all have read under section 191 subclause A that a private complaint, and a complaint is lodged when FIR has been refused by the police officer. So there is a power or a right or an opportunity to the first informant to file a protest petition, right? Now moving forward, everyone knows there is a concept of jurisdiction. Hello. Anyone wants to say something? Okay. So there is a concept of jurisdiction, but this is a very basic thing people skip, that even if the offense is triable by the court of sessions, the cognizance will be taken up by the magistrate only. So in the hierarchy, I'm putting a question to you all: who is having the greater power, magistrate or court of session? Come on, answer fast.
Court of session.
Right? Divyam, court of session have the greater power than magistrate, but also magistrate will take the cognizance. Suppose, for an instance, an offense of murder has been committed. Whole that procedure, FIR 161, 164, charge sheet has been prepared. That charge sheet will be forwarded to magistrate, not to the court of sessions, because the magistrate has the duty to take cognizance, not the court of sessions. Court of sessions is responsible only to conduct the trial. And what do you mean by the trial? Anyone? Trial is basically when the case is started, where the prosecution evidence, defense witnesses, which we call PW, DW, and the statement of accused is being recorded, and the accused, foremost, accused plead not guilty. So, magistrate, after seeing the charge sheet filed under section 302, the offense of murder is committed, and the charge sheet must be filed before the magistrate. So when you go to section 190, you will find magistrate under section 191 subclause B, because charge sheet has been filed. It is the police report. It is the police report on which the magistrate is taking cognizance. Magistrate not stop here only. He or she will take summon under section 204 CRPC, power of summon, summoning the accused. Then there comes section 207 of the CRPC. There is a term: the case is now committed, committed to the court of session, to the jurisdiction who can try the case. So, how will you find who will try which offense? So, again, at the back of the CRPC, at the back of your criminal manual, you will find a whole some chart where you will find that the offenses which are triable by magistrate, triable by the court of session. That's why we write triable by. The trial is to be done by that concerned court, but the cognizance will be taken up by magistrate only. So There is a question I want to place in your mind. There is a concept of fair disclosure, and you will be fascinated to know that fair disclosure means disclosing all the things against the accused which is found during the course of investigating by the investigating agencies and authorities. So there is no concept of fair disclosure in India. When you see some Hollywood movies, series related to the trial and all, or when you read out the cases, you will find out they have the concept of fair disclosure where the things which found in supporting of an accused of not being guilty is also being placed in front of the judge. But here in India, we only club those things in the charge sheet and the report which is placed before the magistrate, which points out the offense, points out the guilty mind of the accused. Many law commissions have already senior advocates, many good names in legal fraternity has already raised a question against this, because if fair disclosure thing is allowed in India, half of the criminal cases will end up. But it would also give rise to not to give bail to the accused who are incriminated in the heinous offenses. So, uh, I think I will take 5 minutes more just to wind up the things, and then we can proceed with the questions if any of you. And if you want this document, I will be giving this document to the host. Okay, so when you look from section 154 to 176, you will find out there are four reports. There is one preliminary report under section 157, and there is then under 168 report to the senior, and then third we already read about 173, that is final report, challan, charge sheet or completion report, and the 174 is known as inquest report or panchnama. That too, there is a difference between section 161 and 164. 161 is considered to be the irrelevant statement because it's given before the police, while the statement given in front of the magistrate is considered to be relevant because the statement given in front of the police is considered to be maybe given under threat or inducement, some kind of inducement. Looking at to section 167, when we talk about judicial custody or the investigation should be completed within 24 hours, then 167 should be read with 57 of the CRPC that it states the time of 24 hours. And that too, if the police wants some more time and has the apprehension that an accused can run away, then a maximum of 15 days time at once is granted by the court. Then, yeah, in short, this is the basic or the crux about the whole investigation as well as proceeding to the trial, as well as talking about the state case or the complaint case under these sections in criminal procedure code. Is there any question anyone like to ask? Anything related to this topic other than this? Anyone? Hello?
Ma'am, I have a question. Sir, you talked about commitment of cases. A magistrate can commit case to a sessions court.
Hmm.
Sir, there are two sections, as I have read,
Hmm.
which deals with the commitment of cases to the sessions court. One
Hmm.
is section 193 of the CRPC, and another is section 323 of the CRPC. So,
Yes.
what is the difference? What is the key difference between these two sections?
Difference between 190?
193 and 323,
Okay.
because they both talk about the commitment of cases to the sessions court. So
Okay.
where we can use 323 and where we can use 193 section of the CRPC.
Can you please read out section 3?
323.
Yeah.
Yes, sir. 146. Sir, section T20, 323 reads as procedure when after commencement of inquiry or trial, magistrate finds case should be committed.
Hmm.
And if we read the section, it is written that if in any inquiry into an offence or a trial before a magistrate, it appears to him that any stage of the proceeding before signing judgment, that the case is one which ought to be tried by the court of session, he shall commit it to that court under the provision herein contained, The provisions of uh, chapter 18 shall apply to the commitment so made.
Hmm.
मुझे समझ में नहीं आ रहा है सर ये 190 चूंकि कमिटमेंट ऑफ केस की आपने बात की थी इस वजह से मैंने पूछ लिया
Hmm.
सवाल.
Hmm. So basically, section 323 is the discretion of the court that can be exercised at any point of time during the trial. But when we talk about section, let's say 193, it's the basic and it's the first instance section where the cognizance of the offense is committed by the courts of section and courts of session. So when you read the there's a plethora of judgment which talks about section 323 can be invoked at any point of time at any instance if a magistrate finds that the case should be committed and tried by the session, and it provides the procedure that after the commencement of the inquiry or the trial. So it specifically says after the commencement of the inquiry and trial, while the section 193 talks about pre commencement, while this talks about the post commencement, right? So when you see that both falls into the different chapter of the CRPC also. This is because this is the miscellaneous provisions and a general provision provided to the magistrate, right?
Yes sir.
Okay, so everyone, this is my LinkedIn profile. You may all, if not now, but in future, have any questions related to anything which I could be helpful of, then you may ask or ping me or yep. Thank you everyone.
Thank you sir.
Yeah. Okay. Thank you everyone. Good night.